Welcome back, everyone. It is my privilege to introduce the moderator for Panel 3, Dissent and Democracy, our own Dean Lynn Inzeroth. Dean Inzeroth is the Associate Dean for Academic Affairs and Professor of Law here at the University of Tulsa College of Law. She earned her JD from Tulane University School of Law, after which she worked as an associate at Bryan, Cave, McFeeters, and McRoberts, as well as Wiley, Ryan, and Felding, both in Washington, D.C., and as an assistant appellate public defender for the Oklahoma Indigent Defense System from 1990 to 1993. Dean Inzeroth also had an impressive career as a judicial clerk before joining us here at the University of Tulsa. First as the senior law clerk from 1993 to 1999 for Judge Charles Chappell of the Oklahoma Court of Criminal Appeals, and then as a clerk for United States Magistrate Judge Banna Roberts for the Western District of Oklahoma from 1999 to 2002. Dean Inzeroth joined the TU Law faculty in 2004, where she has taught constitutional law, capital punishment, and criminal procedure. She has written about issues concerning federal habeas corpus review and prisoner litigation, death penalty litigation, jury selection, capital sentencing, and ineffective assistance of counsel, just to name a few. Please welcome Dean Lynn Inzeroth.
Thank you, Rachel. Good afternoon. Welcome back for the afternoon session of our program today, honoring the work of Heather Gerken. This is a wonderful symposium. I am so pleased to see you all back this afternoon. It's been a delight for the College of Law to host such distinguished panelists and also to honor the work of Heather Gerken. This afternoon, the subject of our discussion, our panel discussion, will be dissent and democracies. And the members of our panel are first Guy Charles, who is a professor of law at Duke University School of Law, Professor David Fontana, who is a professor of law at the George Washington Law School, and Professor Ilya Somin, who is a professor of law, and also Somin. See, with Inzeroth, you'd think I'd be better at this, with last names. Who's a professor of law and also the editor of Supreme Court Economic Review at George Mason University School of Law. I hope you indulge me just for a few minutes. I know you want to hear them, not me. But if you'll indulge me for a few minutes, I'd like to talk a little bit about each of our panelists today. And then we'll turn over our program in just a minute here to Professor Charles. We are going to save questions for the end. Professor Charles will speak, then Professor Fontana, and finally Professor Somin. I'll introduce all before they begin. Somin. Sorry. My students will tell you I'm terrible at this. It's one of my many flaws. Professor Charles received his JD from the University of Michigan Law School. While in law school, he was the founder and first editor-in-chief of the Michigan Journal of Race and Law. Professor Charles went on to clerk for the Honorable Damon J. Keith of the U.S. Court of Appeals for the Sixth Circuit. In 2000, he joined the faculty of the University of Minnesota Law School, where he was the Russell M. and Elizabeth M. Bennett Professor of Law, and later served as interim co-dean. He is now the Charles Rhine Professor of Law at Duke University School of Law, where he is the founding director of the Duke Law Center on Law, Race, and Politics. To date, Professor Charles has published in the Michigan Law Review, the Georgetown Law Journal, the Cal Law Review, and many others. At this time, I'm going to turn the program over to Professor Charles.
Thank you. It is my absolute pleasure to be here this afternoon. Thank you to the members of the Law Review who invited me to be here. Of course, once you mentioned that this was an event to honor Heather, there's no doubt that I was going to be here. Heather is a very good friend, as well as our generation's leading academic. And before fetting Heather, so this is going to be fet, and then no fet, and then back to fet. So you'll see. But before fetting Heather, I just have to tell a couple Heather stories. So I first noticed Heather. We were at the same law school, though she was a couple years ahead. And I first noticed her when there was a bevy of students following her down the hall as a third-year law student. Eventually, I said to somebody, what is that? Who is that? Well, that's Heather Gerken. She's the editor-in-chief of the Law Review. It's like, oh, okay. I guess that's why people are following her. The next time I noticed Heather was when I was the summer before I was going on the market. And I was at Michigan, and somebody said to me, look, you need to come and hear Heather. She's going to give her job talk. So I said, all right, I will come. She gave the best job talk that I have ever heard after 12 years in legal academia, and she did it without notes and spoke in absolutely fluent sentences, and paragraphs indeed. So clearly, this was a person who was destined for greatness and, in fact, has achieved greatness. And it was my pleasure to get to know her and to have been a colleague and a friend these many years. She's a wonderful scholar whose scholarship displays an engagement with important problems. She's an ingenious thinker. She is a thoughtful political theorist. And really one of the hardest working people and conscientious people in legal academia. She's a wonderful soul in addition to all of those things, kind and selfless. And so coming here to honor you, Heather, is my distinctive privilege. There are few who match your great intellect as well as your great personality. So we thank you for being the person that you are in our profession. So my talk today is about one of Professor Gerken's obsessions, which is making democracy work for minorities. And I will use minorities here in the classical sense to mean a group that is a numerical minority, that is socially discrete, and that has distinctive political interests or preferences from the majority. Part of Professor Gerken's work has been motivated by the important task of making representative democracy work for all of its citizens. And that task, in her motivation, is evident in so much of her work: second-order diversity that we've heard about today, dissenting by deciding, federalism all the way down, uncooperative federalism, and so much more. A critical and subtle theme of each of these foundational pieces, as well as others, is that the institutional structures of democracy ought to permit the effective participation by minorities. My talk will explore this particular theme of Professor Gerken's work, and in light of the aims of this panel, I will focus specifically on dissenting by deciding. So what I'll do is first review the basic framework of dissenting by deciding, and then I'll offer some friendly criticism. This is where the not-fetting part comes in. And then I will return to underscore the importance of the work. This is where the fetting part comes back in, if you're keeping score at home. And offer some of the things that we learn from Professor Gerken as a theorist of political power. All right, I call her the power theorist, use of that term in many different ways. She underscores for us the importance of wielding decisive power in a representative democracy. She reminds us that self-governance is not a procedural exercise. It is not simply a symbolic exercise. It isn't participation for the sake of participation, but that self-governance is important because a core component of self-governance is the exercise of meaningful and consequential power. Even the losers must sometimes be winners if self-government is to be actualized. All right, and this is a core theme in the work of Professor Gerken. Gerken is a political theorist, and quite a good one. Indeed, among the many themes that her work explores is the normative morality of minority rule. She is part of a long line of theorists interested in understanding the limitations of majority decision-making and the concomitant benefits of minority rule. Political theorists have long understood that majoritarian decision-making is sometimes morally and normatively problematic. The majoritarianism is an important democratic principle. It is not an unalloyed good. In recognition of the limits of majority rule, political theory has long explored substantive and procedural limits to majority rule. For the most part, political theory has understood that democracy owes something to political minorities. And political theory has been relatively clear that what democracy owes to political minorities are procedural safeguards and maybe a few substantive political rights. Fundamentally, few have questioned the moral imperative of majorities wielding substantive political power, provided, of course, they do so within the framework of established constraints. But within those constraints, majorities are entitled to rule, and minorities are expected to lose. And all of this is normatively acceptable. From at least one perspective in democratic theory, the normative imperative of majority rule is unproblematic because majority coalitions are transitory. To put that in slightly different terms, but in a conceptual formulation that is similar or that sounds in classical democratic theory, majoritarianism is unobjectionable so long as we take turns being ruled and ruling. An important assumption of classical democratic theory is that those who rule will submit to being ruled, and those who are ruled will take turns ruling. This is one way of actuating self-government and justifying the majoritarian act of decision-making and power, not as power as force, but power as right, as legal right. Now, whether one adheres to the more modern Dalian conception of democracy as shifting majority coalitions, or the more classical conceptions that ruler and ruled are ever-changing categories where everyone gets a turn in each condition, the point remains that neither majoritarian nor minority status are expected to be permanent categories. This critical assumption of democratic theory is violated where majority and minority status are permanent or semi-permanent categories. Where minorities in a democracy are perpetual losers, one cannot credibly warrant that they are self-governing, notwithstanding the procedural safeguards and a limited set of substantive rights that may be afforded to the minority by fundamental law. Now, of course, the permanent majority, is certainly self-governing, but it is difficult to make that case with respect to the minority. Where there are permanent majorities and permanent minorities, democratic theorists are presented with two fundamental challenges for democracy. First, how does democracy actualize its fundamental promise, self-rule, for minorities in this case? And second, how does one justify majority rule in the case of permanent majorities and permanent minorities? This is a fundamental and formidable challenge. And of course, it's a challenge that Heather Gerken takes on. She confronts the question, though perhaps not precisely in the terms that I've just outlined, but confronts the question fairly directly and dissenting by deciding. Dissenting by deciding is an ambitious and field-defining piece. It's one of my favorites in the oeuvre of Heather Gerken. It takes seriously the notion that minorities ought to wield decisive political power. Right? It's sort of a multi-layered cake, right? You were talking about dessert, David and I found that we have this thing for dessert. Well, maybe I do, I'm just projecting, thinking that you do, maybe you don't. All right, thank you. Now you can't back off from that. Right? Multi-layered cake where you dig and dig and dig, and there's still multiple and many layers yet to be realized. And this is similar to dissenting by deciding. Gerken's solution to the problem of majorities and minorities is relatively straightforward, which is that we should design institutional structures so that minorities can wield consequential power. So now let's consider the argument in a little bit of detail. Her opening move is the argument that perpetual minorities who disagree with a permanent majority's decision generally have two choices with regard to governance. She terms one, act moderately, and the other, to speak radically. By acting moderately, Gerken means that minorities can threaten to dissent from the majority's decision in order to influence the majority's outcome. Other than that, other than actually dissenting, a point to which I'll return in a second, for Gerken, acting moderately, that is influencing the majority's decision, is the best that the minority can expect, at least when it comes to governance. And so she explains, would-be dissenters who deploy this strategy get to take a part in an act of governance. But it is governance of a moderate sort. And even if the dissenter gets an opportunity to wield the authority of the state, dissent takes the form of an argument, one designed to persuade other members of the decision-making body to take a different stance. Dissenters speak truth to power, to those with a majority of the votes. Importantly, the final decision, even as influenced by the minority's threat of dissent, is not the minority's decision, but that of the majority. The minority is not participating in governance, it is not wielding the power of the state, it is making an argument to the decision maker, which is always the majority. So one version, minorities are speaking and making arguments, but aren't able to affect the fundamental outcome. And the alternative, minorities can dissent, or in Durkheimian terms, I haven't heard that said today, they can speak radically. When minorities dissent, they do so with a critical rather than authoritative voice. They speak on behalf of themselves, not the polity, in any event, whether they are acting moderately or speaking radically, they don't wield political power. And this is the point that Heather wants to make. They are always speaking truth to power, as opposed to acting with political power. In order to act with power, or in Gherkin's terms, in order to act radically, minorities need to dissent by deciding. Dissent by deciding, she instructs, occurs when would-be dissenters, individuals who hold minority views within the polity as a whole, when they enjoy a local majority on a decision-making body and can thus dictate the outcome. Dissenting by deciding is a strategy for creating localized institutions that enable minorities to become majorities and thus wield consequential political power. She makes three distinctions, which I'll criticize gently in a few seconds, but let me lay them out for a minute. Three distinctions with respect to the difference between conventional dissent and dissenting by deciding. Dissenting by deciding, one, is embodied in a decision, not an argument. It gives the electoral minorities a chance to speak truth to power, to speak truth with power, not just simply to power, fusing an act of contestation with an act of affirmation, and dissenters who decide are able to act with the authority of the state collectively rather than acting in isolation. Now, I'll refer to these respectively as the first one as the speech distinction, the second as the consequential expressive distinction, and the third as the private state distinction. Gherkin argues that when minorities engage in conventional dissent, they are always engaged in making arguments. This is her point that even when minorities threaten to dissent from the majority's decision, unless the majority modifies its decision in their favor, a move that she terms acting moderately, dissenters are not really acting but making arguments. Thus, one key difference between conventional dissent, she tells us, and dissenting by deciding is that dissenting by deciding takes the form of a decision. Gherkin argues also that dissenting by deciding is different from conventional dissent because it gives minorities a chance to speak truth with power. The essence of her argument, so I term that the consequential expressive distinction. The essence of this argument is that minorities are able to wield consequential political power in a world in which we adjust institutions to reflect the values of dissenting by deciding. In a world outside of the principles of dissenting by deciding, participation by minorities is simply expressive. Participation is inconsequential because minorities are not sufficiently numerous to have an impact on the outcome. Thus, the value of participation can't be consequential and is expressive. And then finally, conventional dissent is different from dissenting by deciding because it enables minorities to wield the power of the state. Now, there's much to admire in dissenting by deciding, not least of which is the article's ambition, sophistication, and audacity. I'll get to these strengths shortly. But first, I want to raise three questions, and if I'll run out of time, I'll stop at two and can raise the other ones in the privacy of my office or in the paper for the law review. Three questions. Some of the questions she addresses in the article, though not quite to my satisfaction, and some aren't addressed at all. My first question is whether one can remain a dissenter while exercising political power as the state. when a subnational element of the state exercises consequential political power in a federated system, it's hard for me to understand how one can meaningfully characterize that exercise of power as dissent. It seems to me that one loses the conceptual power of dissent when dissent is conceived in such terms. Dissenters do not wield state power. Once they do, they are no longer dissenters, they are the state. And notice that this is precisely the problem that opposition parties have and movements have when they gain the power of the state. Right? At one time, they were outsiders in opposition parties and movements, and then they become insiders and they gain the power of the state. They can no longer behave as dissenters. They no longer have the leeway and the legitimacy that comes with being dissenters. They now have the burden of the state. Moreover, as supporters of those formerly dissident movements have recognized, the powers of state are transformative. The powers of state cannot be underestimated. Former dissident allies who now wield state power are no longer dissident because they speak with force. They speak with the authority and the threat of the state. Now, Gherkin recognizes this problem and addresses it, though, as I said, not convincingly. So to the objection that dissenters wield state power, she notes this is a category error. Such a claim takes an unduly narrow view of power in disaggregated institutions. Because of their minority status, even where minorities constitute a majority in disaggregated institutions, the fact that electoral minorities wield control over some decisions, she argues, within a disaggregated structure does not alter their status as dissenters. Wielding power in one domain, she says, for example, constituting a decisive majority on a school board, does not change the fact that the minority remains the minority in all the other domains. Now I say, fair enough, but, of course there's a but, this response does not meet the central objection, which is that when the minority exercises the power of the state, it is the state. The minority may be dissenters in other domains where they don't wield state power, but they are not dissenters in the domain in which they do. We cannot use their status in the domains in which they don't wield state power to judge their status in the domains in which they do wield state power. This is why we can't meaningfully characterize the decision of minorities when they wield state power as acts of dissent. These decisions are acts of state. Thus, the notion of minorities wielding state power seems to be a contradiction in terms. This then leads to my second question, which is whether the idea of dissenting by deciding is itself, the whole conception, contradictory. Gherkin also anticipates this question and addresses it in the article, and she notes that some might argue that dissenting by deciding is a contradiction in terms. They might be of the view that one can't simultaneously oppose the state and act on its behalf, to which I said, that is so. Some might argue that. In fact, I'm about to make that argument. Now, I think this particular way of characterizing the problem might miss the point a bit. The idea is not that one cannot simultaneously oppose the state and act on its behalf. That shouldn't be too controversial. The clearest example we have is the case of the public defender. Here is an individual appointed by the state, who works for the state, who is paid by the state, who acts on behalf of the state, yet at the same time opposes the state. So the objection should not be to the idea that an entity might both represent and oppose the state. The objection, I think, is slightly subtler than that. It is to the idea that a decision of the state is itself oppositional. Now, she responds to this question when she makes another pass at answering in the article, and she points to the issue of jury nullification as an example of an oppositional decision. Right? She points to other examples. Those, I think, are less persuasive. But the jury nullification one, I have to admit, gave me pause. I found it arresting. But I think it's problematic for the following reasons. If the jury nullification example is right, I think it raises a much more significant problem with respect to the rule of law for dissent by deciding than I perceived earlier. Jury nullification is controversial and oppositional because the jury is defying established legal rules that would otherwise dictate the outcome of the case. The decision of the jury is not in and of itself oppositional, right? Without that context, it's not in and of itself oppositional. The practice of jury nullification may be oppositional, but only because it is contrary to law. If we were to legalize the practice of jury nullification, provided the jury with greater leeway, right, as Gerald was suggesting earlier in the earlier panel, then it would no longer be oppositional. Right? It is only oppositional to the extent that it is in opposition to something, and the to something is clearly established law. Now, while I understand the idea of dissenting by deciding to favor decisional heterogeneity, a point with which I'll close, I don't understand Professor Gerken to be advocating law-breaking in support of decisional heterogeneity. That is, I don't understand dissenting by deciding to be arguing in favor of illegal departures from the norm, right? And if we were arguing from illegal departures from the norm, then we would have a very significant line drawing problem, which is part of the question that Sandy raised earlier in an exchange with Fernita. Okay, I'm going to leave aside my last question because I want to leave room for my fellow panelists. I think it's bad form for the excellent first panelist who has great and important things to say, deep, thoughtful things, to take the time of the Lilliputian second panelist. That is, of course, not true. These are friends, thankfully, though not for much longer.
I just say.
So let me close though with what I think are some important points about dissenting by deciding. In many ways, one could argue, or I will argue, that these criticisms are beside the point. That it's not clear to me that the main lesson of dissenting by deciding hang on the distinctions at the points that I've made. Recall here that the true question at hand is, what does democracy owe to minorities? Put differently, what are the commitments that a society which is committed to self-rule owe to permanent political losers? Is it normatively acceptable for a democracy to say to political minorities, self-rule for me, but not for thee? Gerken's answer is clear and unequivocal. The promise of self-rule must be kept for minorities as it is for majorities. Moreover, it is insufficient to provide procedural rights of participation, such as the right to speak or vote. It is also not enough to protect a limited set of substantive rights. Minorities are entitled to wield consequential political power. There is a morality to self-rule, which is one of the lessons that we take from our article. It may be a contingent morality, all right, maybe contingent moral imperative, or more precisely, it is contingent in some circumstances, right, but it is a moral imperative nonetheless. So, 5 very quick implications. First, we have too long neglected power and the fact that power matters. And one of the things that Gerken does in her work is to point us to the importance of power. Second, decisional heterogeneity is a contingent normative good. Assume a world in which there are multiple minorities with distinctive preferences. We ought to prefer decisional heterogeneity as opposed to homogeneity. Third, it also follows that whenever we can design institutions that reflect decisional heterogeneity, we ought to do so. Now, those institutions ought to be consistent with other democratic commitments. So, again, this is the contingent normative point. This also means that there is a normative value to disaggregated units, right? Federalism all the way down. Fourth, it also means that we ought to be skeptical about nationalizing and constitutionalizing fundamental commitments. This is, again, to refer to Sandy's question to Fernita. What sorts of commitments ought to be constitutionalized? What sorts of commitments ought to be nationalized, and which ones ought not to be? The answer from Gerken's work is, well, look, few commitments ought to be nationalized, because then that permits the heterogeneity that we need and permits for disaggregated institutions. Fifth and last, there's a particular lesson here for race scholars that has influenced my own work and the project that I'm currently working on. Scholars of race ought to care more about federalism, Ernie says yay, and federalism scholars ought to care a lot more about race. Race scholars are nationalistic, which is strange and paradoxical if you take the lessons of dissenting by deciding seriously. Federalism scholars are often race skeptics. That too is strange and paradoxical, right? They've got it all backwards. So from Gherkin, we ought to learn that, look, if we really care about minority rule, right, we ought to care about federalism and heterogeneity. I leave you there. Thank you, Heather, for such illuminating work.